What up, T?
What's happening, mate?
Not a lot, bro. I just ate some food. That's why I was a bit late.
All good.
Yeah, how you been, brother?
Lots of reading.
Hey, that's what I like to hear. What are you reading?
Mostly just going over credit, bills of exchange, that kind of stuff. To me, it seems like the only one that's, well, not the only one, but the least obfuscated of all of the things you guys are juggling. So it's like a little bit easier for me to understand.
Yeah. Bills of exchange is very, very clear cut. The issue that everyone has is enforcement. It's yeah, bills of exchange. It's very simple what they do and how they're used in our economy. But the issue everyone has is enforcement. And I was just talking to a friend tonight about how that all fails, where it falls down, where we fall down. And it actually applies to this police audit that I'm, wanting to do. Because it's like these companies rely on their internal policies, guides, procedures, and manuals to determine their decision-making process. And they do so with a blatant disregard for federal legislation. And this is, they've made laws that allow them to call acts, statutes, and legislations laws. And much in the same way police use acts as law, companies use internal guides as justification for their decision-making. Now, we let them do that by our failure to not only administrate. I think most people are aware of what's required in an administrative process, but where we all fall over, it's, you can follow as many templates as you want. Boy, inside. You can follow as many letters as you want and nail them to a T, and even add some really critical things that you think might help get them to see things the way that you see them. I relate that to arguing on the side of the road with the police officer. It can work sometimes, but it's time of day, mood. Did you get a root the night before? Are you too difficult? Did you not piss him off and he just wants to go away? These same logic processes are followed with, Telstra for some reason, whether it be my trustee position, the public trustee appointment or whatever, or they've just decided to honour. I don't know, but they're able to do these things to us or against us, or breach our human rights, or detain us unlawfully, or not keep our bills of exchange and not honour them, because we don't adjudicate the matter. We're always on the defence. They file against us, default in court. Councils, for example, they adjudicate the matter in your absence. We allow these things to happen to us when we need to be, not just if we're going up against police, if we're going up against a bill of exchange matter where we've been, we're now in dishonour, we're not going to get remedy going into a magistrates court. And I've come to realise that now. What we all need to learn how to do is, take a matter into the Supreme Court and we go for adjudication there. And I think this now applies not only with what I'm going to try and do tonight with this police audit stuff, but if anyone's sending bills of exchange, I think that's where we need to go. And I think everyone, it might sound daunting for some might be excited, but I think everyone, when they start trying to govern their own lives and they start making decisions that they haven't made before and doing things that aren't the acceptable norm in society, we need to understand that what we're doing is serious and be willing to go into court and stand on our business. Now, magistrates court, it's a joke. I haven't had any dealings in Supreme Court, and I don't know many people that have had. I do know of some dismissed cases, but I think a well-presented claim with evidence to back it up, it does get heard. You do get your matter heard in a bipartisan way. You might have overreach of the judge practicing from the bench, but when these sort of things happen, you know what you're doing, you know what you're talking about, it, and you stand on it to the point where you go, well, I know I'm right still. You've ruled against me. I'm appealing and taking this to the High Court. So just a bit of a preface how I feel about the whole situation. I'll admit when I'm wrong, and I like doing it because I fucking learned something. I was under the impression it was Magistrates Court, High Court, and Supreme Court. I was wrong. It is Magistrates Supreme, then High Court. I have a bit more faith taking bills of exchange now because I see a difference, and I see a way that you can actually get the law administered over an act. So does anyone have any questions about what I just said or ranted on about? Speak up.
Yeah, I kind of assumed that the courts below the top level were more about an administrative process and not really about following the laws like this is what we do at this level. It either fits what we're going to do or it doesn't.
Yeah. I don't know. They're a company. People call them banks. They're doing commerce. They're going for volume and keeping the status quo. And I think that it might happen, potentially will happen in the Supreme Court, but they're a lot more hesitant on getting a strike against their record, because if you get an appeal, to go through, looks bad on them. If you get a couple of appeals to go through against that judge, some of them stay in, but they can't hear serious cases and their career goes down the toilet. So they're a lot more careful on what they say and do in these higher jurisdictions. Anyone else have any questions? Any other questions about what I said? People doing shit, sending letters. Does the thought of court scare you? And, we can all speak honestly here. Nope, everyone's keen on court. Love it. All right, we'll get into my idea about this police audit, and questions as we go would be good, but you do you. Now, I'm just going to share the screen. I'm pretty sure that's the right document. Yeah. So, this is an explanatory document that I'm going to put in the group. I might actually drop it in the group now in case anyone's like me and they like looking at it at the same time. But yeah, this is just an explanatory document where I try and I haven't even saved it yet. All right, give us a sec. Fuck it. We'll go through it. I'll drop it in after while I'm not sharing screen with you, maybe when you have some questions. But this is just an explanatory document as to why I think what I want to do seems legitimate and enforceable, in my opinion. So I guess I'll just read through some stuff. Hamilton v. DPP, Kaz posted about it in the group. It's probably the best case law because it is actually applicable to what we're talking about, but as you'll see, and you've probably seen in the chat, I've found another 20, maybe 25 now that talk about the issues with statutes in comparison to constitutional law, the Constitution, and the common law or the law merchant. So, in the landmark case, Hamilton v. DBP, the court scrutinised police powers under Section 59 of the Road Safety Act. This case exemplifies the ongoing issues with unchallenged statutory powers granted to police and the principles of common law and constitutional protections. In Hamilton, the central issue revolved around whether police could lawfully stop or detain a person for the purposes of obtaining their identification without reasonable suspicion of a crime. The court found Section 59 did not provide a statutory basis for such broad powers. Now, Justin Kavanagh, his statement emphasises this. Section 59 of the Road Safety Act is not a statutory source of such power. The power to stop a person for the purpose of requiring them to state their name and address must be supported by specific, articulable facts, creating a reasonable suspicion that the person has committed, is committing, or is about to commit an offence. Now, this case underscores and highlights for us the critical legal principle that statutory powers conferred upon police must align with common law principles and constitutional protections. It highlights the importance of ensuring laws do not overreach and infringe upon fundamental rights of individuals. In Hamilton, the High Court, fuck me, my computer's going to die. The High Court addressed specific tension between statutory provisions and common law principles. The case focused on the interpretation of Section 59, which police claimed granted them the authority to stop and demand identification without specific suspicion of wrongdoing. The court's rejection of this interpretation affirmed that statutory powers must be exercised within the constraints of common law and constitutional protections. This decision reflects a broader legal and philosophical debate about the limits of state power and the protection of individual liberties. Comments, my friends. I've got to do a computer switch. So jump in. Tell me what you think. Tell me any issues. What's going through your minds.
Who enforces this?
We do, but what do you mean?
Like, you know, say you memorized all this, they pull you over illegally. Is the most anyone can do throw it at their face, but still kind of get stopped, run over?
What do you try again so I can understand what you're saying?
Like, are there police to police the police? Someone that's going to actually get up them?
That is a great question, my friend. You're talking about police, investigating police. There is... Look, I don't know about police, actually, and I think they would have dissolved whatever powers they had. But it is the judicial review when you have an issue in court like this, where it's judges, investigating judges, and they, we've got two ongoing cases with the ombudsman and other, like the attorney general and all that sort of stuff. Nothing happens. Okay, so unfortunately, if a police acts outside his scope of office, we have to be that police review. If there is a position like what you're talking about, it's not going to provide remedy in that regard. Anyone else have any questions before I open this document back up and start reading from it again. Crap, I don't even know where I put it now. Right, well, I'm back in. But yeah, so like that's a great question, T, but the enforcement and the spanking, the slap on the wrist, if you will, that the police would get, it's not from within, it's from without, and that is us. And we don't get to do the spanking. We have to present our argument in such a way that the judicial system does the spanking for us. We need to be ready to argue it all the way through, but typically what happens is a settlement offer, right? And that's where my audit is going to inevitably lead. So I'll quickly explain why I believe that this is a great idea and what its purpose will serve. It probably should be in this document, but I was just spitting shit at the time. But the police audit would serve two purposes. One, for unlawful detention, where you're able to articulate your position on the side of the road and the police officer lets you go free. And I've written up a statement of claim, so you'll see where, statement of claim 1 lies, and that's on that principle where you get out. And then statement of claim 2 will be where you're not only unlawfully detained, where he hasn't been able to provide reason for stopping you, whether it be in the train station, out in the public, or in an automobile. He unlawfully detains you, doesn't like what you say. You go, okay, you're not listening, you're not willing to explain your position, and you're trying to now arrest me. Please bring a supervisor. If you've been unable to maintain composure throughout the ordeal and it's escalated to that situation, I've been there, done that. They don't provide a supervisor. They already just see you. We've all been labelled. People who ask questions, there's a document that goes around to all the police, and we're labelled, categorised, and taught. They're taught how to deal with us. And calling a supervisor and bringing them to the scene so that the supervisor can potentially spank them on scene and say, no, let him go, that's not taught to them. You need to be able to explain that to them before the situation escalates. Now, statement of claim 2 is where you're arrested and taken back to the precinct, and I will be there, and I'll refuse to give a name just on principalities, and they have a right to hold me for 24 hours. Unless they call me a terrorist, then they can hold me indefinitely, and you've sort of got to do habeas corpus, and you got to have a go bag with some family that are ready to go looking for you, find what precinct you're at if you got locked up in jail, and you go habeas corpus, produce the body of the contract, and hopefully you'll be brought out of the court, out of the jail, out of the fishbowl, whatever, or you'll get put in front of a judge and you got to explain your position there. That's worst case scenario. But there will be 2 statement of claims, unlawful detention and unlawful arrest. Both of these statement of claims will have an affidavit for each specific one. And within those affidavits, we will be showing it's penalty units here. So when there's Crimes Act stuff, it's penalty units, but you go and look up, I used to know this shit off by heart, but it's like $140 or something like that. Each penalty unit can be liquidated into a dollar amount, and then when there's prison sentences attached, there's another dollar amount that you can liquidate it into also. So the reason for this audit, unlawful detainment, where you manage to get out of there, you just start filming, stopwatch, how many minutes you've been on the side of the road, stop it again when you drive away, and then you go and put your claim in and liquidate for those damages. An unlawful arrest, it's more serious, but it's a time frame thing, and then the laws that he's breached. We'll be using the Crimes Act stuff for the penalty units for those laws. We're not going to be using nothing in their fucking Road Safety Act or Road Transport Act is going to be applicable to us. other than rebutting it in our affidavit as to why they were able to use it. Now, what this means is anyone who does this should be so confident in it that they want to go to court, middle finger to, your rights being breached, your human rights being infringed upon, and you should be ready to go toe-to-toe with the DPP, the Director of Public Prosecutions, and adjudicate this matter yourself. No lawyer will touch it. We might find one, but you need to, and even if you do, you need to know what the hell it is you're doing. But with these affidavits, you should be able to research and figure out, you guys might be able to pick holes in it, and you go, fuck, let's cover this so that we patch this leaky hole before it brings down the ship. And this will only come through trial and error. But essentially, you need to be ready to take it all the fucking way. You need to be ready to go straight away. If you get fucking arrested, you get slapped with a court notice or whatever, you're immediately going to take the statement of claim that we all write up together and your affidavit, and you're going to go file that in the Supreme Court. There's no fucking around in the magistrates. There's no arguing what they've arrested you for. You're doing what's known as a cross-claim, counter-claim, you're filing a completely separate case. Whatever the hell they did to you and they're trying to get you for, good on you. Even if you get into a fucking biff with the bloke on the side of the road because he starts acting a fool, your cross-claim, counter-claim will put in a self-defense clause. No one should do that, and if you hit a cop, you're fucked. But there's a way that you can go and get your matter heard first. That is via a cross-claim, counter-claim, and not only that, you put it into a jurisdiction higher than theirs. The higher jurisdiction must be heard first before the lower. Now, why you need to be ready to take this the whole way is because if you fuck up, they're going to smell it on you. If you got fear, they're going to go, let's find out. You're going to get tested. So you need to be so damn confident in what you're doing and what you believe as a man on this fucking land you're entitled to, what the internationally protected human rights laws say you can and cannot be done to you, and then what our own federal legislation says, what our Constitution says, and what the precedents of all the past common law merchant laws define as being right and true and able to be done. You need to be able to breathe them, wake up in the morning and piss them. But what I'm saying here is you need to know if you're going to drive around, you need to be ready to take it the whole way. If you're going to deny providing identification, you got to know what you're doing is very serious, not because of what you're doing, but the implications thereon. So, prefacing that, you need to be ready to do that. However, what this statement of claim and affidavit will essentially do is you'll either get unlawfully detained, get let go. Unlawfully detained and you express your rights, you're still denied under duress. You give him your ID. If you have a driver's license, you give it to him. If you don't, you decide to give him your name and he might still arrest you. Who knows? Either of those two situations happened after an arrest. Irrelevant. A day later, you're released after you didn't give ID. Same situation, just a longer time frame. But essentially, what this prepared statement of claim and affidavit will allow us to do is when we are free, we will send it. You can send it in a fucking email because it doesn't matter. You need to be ready to take it to court. You can send it to him in an RPP letter if you want, but it has nothing to do with your court process, sending a cop an affidavit. He will just put it in the bin and laugh at it if he doesn't think he has to deal with it. But if you email him or letter it or post him your statement of claim and affidavit, not the police officer, Director of Public Prosecutions, you would then attach a cover letter where you say, you guys have overreached, overexerted, you've violated my human rights. here is my statement of claim. This is exactly how the events transpired. And here is my evidence to support why what you did was not okay, why what you did was unlawful. Not only unlawful, but illegal. What this will essentially do, if we lock this thing in tight, they will go on the bottom of your cover letter, you say, this is me in good faith offering you a chance to settle the matter before we go to court. And that's all it is. And again, I hold it's like them deciding to honour your bill of exchange. It is up to their discretion. And they will smell if you're just a shit kicker and you've got a template of Gov's Gone Wild, they'll go, fuck him. Let's see him in court. You know, because he's presented the facts, but can he argue it to a prosecutor who's dealt with people like us, who's good at confusing you? This is why you need to go the whole way. But essentially, a police audit, you shouldn't have to go to court, because if you know what the law is and then you entrap them into saying something that is unlawful, or they make a claim that something is the law when it isn't, you now then have a valid court claim, and there's a big chance that they will decide to settle on your liquidated damages for 10, 20, 30, 40, 50%, 75%, I don't know, but they'll want the matter to go away. So, comments. Would love to hear what you guys think about the situation. What up, Cakes? I just saw you're in here.
Yeah, just in listening to you, Gov.
I'm fired up, eh? Right, no comments. Cool. As long as everyone understands.
I've got a comment, bro. I've got a comment.
My man, shoot it straight.
Yeah, bro, I'm loving what you're saying. So I definitely went in half cocked when I had the interaction with him, and I haven't made any moves yet, but I'm absolutely loving hearing what you're saying and how you're putting it together right now. Like, it's just making me think and making me smarten up, and yeah, keep it going, bro. Keep it going. I'm just listening.
Nice, man. Yeah, it is what it is. I didn't think about it like this prior. It was only from another matter where I decided to look at, like, I don't know, the common law. I used to not like it, but there is ways that we can use it to our advantage. You know, just like if you've got mental issues or whatever, you can make it your enemy or you can turn it into your friend. It's just all about perspective, and I think there's lots of shit here that we can use to our advantage, and there's a lot of people that are arguing shit, whatever it may be, but without really willing to dissect the problem to its root cause, to a point where you can pull it down to its bare bones. And you know, your statement of claims or whenever anything goes on, it should be really on a single matter, and you can use others to justify it. But if you're arguing one single point, which, you know, I'm not the best at, I'll be the first to admit, you know, I start grabbing at everything. But something like this, as serious as it is, if you nut this thing down to one point, you know, you can go toe-to-toe with a really experienced prosecution, and if you keep your cool and you stay on point and you don't let him, like, trick you into arguing something else that's irrelevant, we have the ability to go into a court and get our matters adjudicated correctly. Now, you know, bills of exchange, it's another thing. I'm of the position that I could potentially go in and hang. Now, I'm not confident that I get a win, but I think I could go in there and speak the facts to a point where it would be something getting ruled against and I would have to appeal it and go round two, or I would just simply get pissed off, like emotional, and, you know, get angry. And all of a sudden, as soon as that happens, like, they smell it, they see it, and you've lost. You can still appeal anything, but if that's what's going to happen, then, you know, you're not ready to go into court. If someone not following your acts that you're stating and stuff like that makes you emotional, you're going to take an L and have to go and, you know, try again or whatever. But this is the thing. I think if we can all work on something that is super, like, there's one thing here. They're using an act that they've passed other acts to allow them to call it law, and that act that they've passed does go against 20, maybe 25 high court case laws where it clearly and unequivocally states that legislation, acts, statutes, and codes must be in line with the common law and constitutional protections. Now, if you can point at what isn't in line with those two things, and you don't fuck around with, you know, 20-page affidavits and a huge statement of claim, you've got a very good chance of a settlement offer. Now, a win, like, that's going to be huge precedent, obviously, and, like, I don't think, like, they just drag that shit out. I think we should all use this as a learning experience. I'm going to go and put it to use, and I don't think anyone else should, but it's up to you. But this is a learning experience on how to write your own statement of claims, because I've had a bit of light shed on as to why things are made so hard for people. It is the judicial system and businesses not following federal legislation, but it's an ish us, not an ish them or an issue. It's an issue with us, not them, and our ability to stand on, you know, our principalities and then find the laws that support them and run it. Yeah. So one sec. I'll put that screen share back up. You guys all see that?
Yep.
Hold up. All right. So the common law and constitutional protections, I'll just read it out and we'll shoot the shit about it in a minute. But common law principles in Australia have long emphasised the protection of individual liberties and requirements for law enforcement officers to act based on reasonable suspicion or probable cause. Again, we don't find that as enshrined in any common law or constitutional sort of arguments, but it is, you can deduce that these two sentences are being said when you read the High Court case law. It's like in America, it's written clear as day. And we have to use discernment if we're going to use these sort of words, because you'll get labeled straight away as well. You need to lead the other party into seeing what you're trying to explain. You know, you can say, because of this, your reasonable suspicion, probable cause, blah, blah, blah. But just saying that, it carries no weight. It's just like citing an act in a fucking notice to Telstra. They're like, well, good on you, bro, but our company policies say otherwise. You say this in court, they're going to say good on you, but our past 700,000 road cases say that you're wrong. And if you get tripped up on that, you've lost the case. But if you have a plan on how to explain why these two things are required, then you can lead the judge and the prosecutor for going, okay, maybe we're best off not pursuing this issue any longer. Now, the principle of reasonable suspicion is foundational in preventing arbitrary detention and ensuring police powers are exercised judiciously and justifiably. The High Court has repeatedly affirmed this principle in I tried to keep it specific here, but this document, I just wrote it before I made dinner tonight. This case, RV Streetfield in 62, this case established that police must have reasonable grounds for suspicion before conducting a search or detaining an individual. This, again, they're not driving cases. There's very few, because these are the driving, or Hamilton is the driving case where someone he probably wasn't offered a settlement. He probably had to take it the whole way. And that's why we have this case law to rely upon. But these were seizures, stop, search and seizures, walking, I think. And same here in Williams v. R. I gotta go read that as well, and we'll pull out quotes on that and how to apply, and then figure out how to apply them. So, like, here's where you go, well, look, I'm arguing that I was driving a car. They're going to flip that on your head so quickly and confuse the shit out of you that if you do not know how to apply a walking individual to a driving man, like, fuck it, we got to use their words. If you start talking like man, person, all this sort of shit, they get their backups because they know they have to defend. But if you just argue, right and wrong, you don't need to separate yourself from the name. You're the plaintiff, and, it is what it is. Just, I think that's another conversation for another time. Now, the constitutional protections, again, I need to go read all these. But the Commonwealth 1901 provides several protections against police overreach, ensuring statutory authorities do not infringe upon individual rights without justification. Section 51, 31, 80, 92, and 116, among others, enshrine rights that protect individuals from arbitrary state actions. I could comment on everything that I'm saying, but for brevity, the High Court of Australia has played a pivotal role in interpreting these constitutional protections and ensuring these statutory authorities operate within the bounds of the law. Now, the difference, legal and lawful, they should be one and the same, but we are where we are. This common law principle of the principle of legal, as discussed in the speech by Chief Justice French, presumes that the Parliament does not intend to interfere with fundamental rights from and freedoms unless it expresses this intention in clear and unambiguous language. This principle acts as a significant protection for individual liberty against arbitrary detention, as protected by the High Court precedent in common law and the Constitution. Arbitrary detention is going to be a hot word that you'll be using because of that's how they discuss it in like the international, I can't remember. So the Universal Declaration of Human Rights, the ICCPR and the ICESR are our fundamental, they're our internationally protected human rights laws. And they all have articles on arbitrary detention, social security, right to self-determination. So, like, I can say I'm a whatever religious, like, I was going to say a fridge, but I don't even want to get into that. But, like, you can claim that you're a Christian, Muslim, or atheist, whatever, you can't be made to define yourself.
And that's because you're arguing against...
I'm trying to... My computer's clapped. Yeah, blah, blah, blah. Arbitrary detention, that's going to be a hot point. So the constitutional interpretation in that word v. the Commonwealth, as mentioned in Justice Dean, stated that the provision of Chapter 3 of the Constitution was based on the assumption of traditional judicial procedures, remedies, and methodology. Now, what is that? That is your common law. Unfortunately, the common law is not what's right and wrong. Cause no harm, loss, or damage to another man, woman, or his dog. That is not what common law is anymore. It is the traditional judicial procedures. That's it. It is the societal norms of how it is acceptable to act as defined in high court case law. That's it. That's all common law is. It is our high court case law rulings and the law merchant, contract law, what in America they want to call UCC and shit like that. That's what that is. The remedies and the methodology. The remedies is when shit happens here, this is what you get paid. Your damages, whatever. The methodology is through the High Court. This suggests that constitutional protections are interpreted in light of common law principles. So they look at our Constitution and what's been determined in the High Court previously. So like here, again, you'd want to arm yourself with some shit that they're going to use against you. And you got to be ready for it and be prepared to rebut it. Because they're going to, you bring a case like this into the Supreme Court and you botch it, or the DPP wants to go toe-to-toe with you, you bet your bottom dollar that they're going to be ready to, they're going to be prepared. And they're going to do the same amount of research that I hope you all would if you decide to do anything like this. Now, the separation of powers, the High Court has consistently upheld that detention is a form of punishment. Key word there. That can only be imposed by the courts, not the executive government. This principle limits the government's powers to detain individuals without judicial oversight. Now, here, I just, like, after I was rereading it, the implications of fines, anyone? Why? Because we don't challenge them. So this comes into, like, we don't have a Bill of Rights, but we've got High Court case law that says the same thing. No man, I can't remember. All fines and forfeitures are null and void prior to a criminal conviction. I'm sure you've all heard that sort of saying before. Well, they're right. We want to claim and complain that they're fining us. Well, we're being pea-hearts and not taking them to court, not doing a cross-claim, counter-claim on them. I wouldn't even want to argue the fine. I'd be like, why did I get fined in the first place? What happened? Was I like stopped on a train and made to produce ID and then, you know, they fined me for refusing to produce the ticket? Well, cross-claim, counter-claim, straight to the Supreme Court. I think that would be far smarter and much easier to adjudicate than arguing their claim in a magistrate's court, because you're probably just going to have to appeal it and take it up to the Supreme Court anyway when it doesn't go. Like, if you're like me and you argue things on principles rather than what other people say, you'll go, well, that's fucked. I know that this is not fair, and then you'll have to appeal it. So why bother playing in their room first? You take it straight up. Now, statutory interpretation. Lacey v. Attorney General in Queensland, as mentioned, 6 justices in a joint judgment emphasised the importance of applying statutory criteria properly. This suggests that statutes must be interpreted and applied in a manner consistent with the common law principles and constitutional protections. Enough said. Protection against arbitrary detention. I like these two. Williams v. the Queen. George v. Rocket. That one's pretty common in the space. The High Court emphasised that detention must be based on reasonable grounds and factual circumstances. I like it. This aligns with both common law principles and common constitutional protection against arbitrary detention. This one would be used in your affidavit, I would imagine. Limits on police powers. Cases like Plenty v. Dillon, I'm sure we've all heard that one too, and then R v. Hulme, highlight that police actions must be within lawful boundaries, which are defined by both statutes and common law principles. Right. Comments. Anyone got anything to say?
I got a couple of things that I thought of while I was listening to you. I know a couple of guys that have been doing this for a bit now, but they take the route of, I guess you could call it conditional acceptance.
Yep.
So they plead guilty, but for a fee. And they list their schedule, and I guess it goes through. Because I know one of them definitely has his own, like, privately registered vehicle, and he's been traveling like that for years. But I don't know the full details of his situation. But I know it definitely works.
Big claim, brother. Has he got any evidence to back it up? Because I personally have like researched myself out of taking that path because of some of the things that I see wrong with it. And number one would be you end up in a court anyway. But like, I'd love, again, you know, if you want to get your mate, have a chat to him or whatever, and maybe try and understand maybe what he wrote, who he sent it to. Like, that shit works, bro. But it's because he said something that was fucking, he was switched on and he said the right thing. And I don't think I've found that right thing. So it could be an issue with me, not an ish him.
Yeah, like I know every time he's gone to court, he's technically been guilty and he's pleaded guilty. But
yeah,
he got paid for it.
What?
So, yeah, I've been there while he's been arrested a couple of times. But after a while, everyone kind of knows him around here. And then they just stop fucking with him because it costs money.
That's a real claim to fame, I reckon. Are you the guy that was in that Zoom with Jill and I the other day?
Yeah.
Nice. My man. Cool. No, like, yeah. That's going toe to toe in the court and standing on business, right? So that's a very similar approach to arguing it in the magistrates court with the same facts as what we're talking about here. You know, you could present this to the magistrates court and go in and conditionally accept their offer upon, you know, an affidavit under penalty of perjury by the other party or the DPP that I'm wrong, and you would get settlement in a magistrates court that way. So I don't see the issue. I don't see anything wrong with what he's done or what you've said. I do believe that because I know who you're talking about. But I don't think that's not for the faint-hearted.
Definitely not. Like, if you didn't have your shit locked down, I wouldn't have even brought it up.
Yeah. There's two dudes that I know of. There's another bloke in far north Queensland, Nibsy, and then a fella in Ireland. And these boys, like, they'll just go in there and they call them fuckwits, you know, and they stand up and start yelling and getting mad. Now, I couldn't do that, but they were able to, you know, they say you can't yell, you can't swear. They go, oh, fuck, I can't. It's an ability to stand on your business like you wake up in the morning and breathe it, and which, you know, maybe one would get to that point with experience, but I think I would, I'd like to, yeah, bro. I think there's potential here in what I'm talking about. Like, you guys can obviously tell I'm excited, but like, this isn't bulletproof. This is fucking real pear-shaped at the moment, and it'd only be from, you know, getting a brain trust together and, you know, picking it apart after we put it together. And it's just, you know, you deconstruct and reconstruct 5 times, and all of a sudden you realize that, shit, I was maybe barking up the wrong tree.
Does this prospectus take into account, like, special powers? For instance, I noticed they put the terror threat up. I wonder if that'll change anything.
Yeah. No, that's a good point. I haven't taken into account anything, being honest with you. This is my own beliefs that I've researched and found evidence to support my belief. And as we all know, that's a very dicey place to come from. So, yeah, no one take it with a grain of salt. Your boy is just figuring it out as he goes, but it's trial and error. And this is why I was, putting a call out for people, but I thought, I was going to try and write this shit up with you guys on the chat, but I got excited and started doing all this shit. But look, so we'll keep going. Conducting police audits are essential for ensuring compliance with legal standards, right? So make sure that they're upholding common law principles and the constitutional protections and preventing arbitrary detentions or unlawful arrests, blah, blah, blah. Protecting our rights, maintaining accountability. This 2 or 3 of these in a state, even in Australia as a whole, and this will begin to. There'll be a notice that goes around to every precinct. Don't say, and I'll run you through my statement of claim before we tap off. They'll be saying, don't say this, because my police audit is going to be, because I will be entrapping the policy enforcer into saying something, right? So the second one of these gets across, they're going to go, all right, don't say this. They're pretty dumb though, so you might get it going for a year en masse, but this thing won't be applicable for any longer than a year, in my opinion. But anyway, in the case of Hamilton v. DPP, highlights the critical need to balance statutory powers with the common law and the Constitution. By conducting police audits and challenging these detentions, we will help to ensure that law enforcement operates within the bounds of the law, respecting our rights and maintaining the integrity of the judicial system, legal system. These efforts contribute to a society where the rule of law prevails and freedoms are upheld. So it safeguards the public's rights, it upholds common law, it ensures the Constitution remains true. And then again, this is where we're going to rely on a lot of shit out of our affidavit. Actually, there's going to be 4 points in our affidavit regarding these 3: federal legislation and international legislation. So the Universal Declaration of Human Rights, Article 8, I think, and then the ICCPR, which is the International Covenant on Civil and Political Rights, and then the SCR, which is International Covenant on Economic, Social and Cultural Rights. These we will fall back on, but we're going to be using High Court as our evidence. This is just going to be an icing on the cake, for example, or that might be our primary argument. I'm not sure yet. Now, Whitfield was an interesting High Court case law that I hadn't heard before today. And it relies on Section 92. I'll read it for you guys. I didn't really. Maybe you guys could throw in your 2 cents here, because I was just I don't know. I knew I wasn't seeing what I was supposed to see in it. So the principle of this case was that the High Court established that states can make their own laws as long as they do not contravene the Constitution and are consistent, not inconsistent, with common law principles. Now that, again, I think 112 maybe, it states that blah, 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 so long as they are not inconsistent. So, maybe someone wants to chuck that up or Google it while I'm reading through this and then drop it in the chat or just sing it out. So some key quotations. Section 92 states, the court, on the interpretation of Section 92, the court is now in a position to reconsider the interpretation of Section 92, free from the influence of past decisions, to construe the section in light of the text of the Constitution as a whole, its historical background and emergence of Australia as an independent nation. This is key because you need to go into court and say to them, although the legislation says I'm wrong, the Constitution says so long as no laws are passed that are inconsistent, I wish I could remember it. But we would be using this to say, hey, although the courts usually look at the form of the relationship, the High Court has held that one must look beyond the form and look at the substance and the nature of the relationship. So the form would be you're driving a car, we need to know who you are. Okay, I get that the legislation says that. However, we must look beyond the form, which is me driving a car, and look at the substance, which is, what's the substance? I've been unlawfully detained. I'll shut up because really it's that simple. And I think I will confuse everyone in the chat just as much as I confuse myself when I talk about this stuff. But this is how you would use this. You must look beyond the form and look at the substance so that you can adjudicate on the nature. Now, there's a famous quote. Well, it's not famous, but I just thought it was sick. Commercial Bank versus Amedio. Justice Mason says, although the courts, blah, 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 it has been held time and time again that we must not only rule on the substance of the relationship or the form, but take into account the nature of the relationship also. So you throw that quote in there as well. Now, on the relationship between state laws and constitutional protection. A law which has its real object in the prescription of a standard for a product or service or norm of a commercial conduct will not ordinarily be grounded in the protectionism and will not be prohibited by Section 92. But if a law which may be otherwise justified by reference to an object which is not protectionist discriminates against interstate trade or commerce in pursuit of that object in a way or to an extent which warrants characterization of the law as protectionist, a court will be justified in concluding that it nonetheless offends Section 92. So, I still, the first sentence and the last sentence makes the point. It's all the word vomit in between. I just noticed one of the homies dropped Section 109 in the chat. So thank you, Jackie. Thank you, Jackie. Now, yeah, it says, if it's inconsistency between the federal and state. I'm going to butcher it. I was looking for the actual section. I'm going to confuse you guys. But so, look, I've read this to you and I feel like it's important, right? Please jump in if you're able to explain it in a paragraph or sentence, ideally. My man. Oh, Jackie, you're a legend. So look, what I do when I don't understand stuff, and particularly when I'm reading stuff about securities, and literally acts and statutes, often I don't get them, but what I do is copy them in and chuck them into, I used to use ChatGPT, but Perplexity, even Bing, the Microsoft browser, chuck it into that, copy and paste it and say, please explain this to me in layman's terms. Now, if anyone wants to do that while we're on the chat, you don't have to read it out to me if you don't want to, but it would impress me if someone actually did do that and then, either read it out or dropped it in, because we will all learn from that. And that's how I shorten up this shit fight that it's known as reading the law or legislation. Now, On the consistency, the freedom guaranteed by 92 is not absolute. This section does not prohibit all regulation of interstate trade and commerce. It prohibits only the impositions of discriminatory burdens of a protectionist kind. I want to read that and say it prohibits the imposition of discriminatory burdens that are not in line with common law principles. But again, you can't take this out of context. You could copy and paste this into your AI and go, is this what they're referencing? What do they mean by discriminatory burdens of a protectionist kind? Could he be talking about the controversy between the legislation passed and the common law principles and constitutional protections? And it'll tell you an answer, which you won't take that wording as it is, but you'll be able to understand it and use language that supports this to mean something that you can articulate in your own words. This is how I am able to comprehend things that I just truly do not get. And sometimes it takes me reading documents twice or three times. But rather than glazing over something you don't understand, if you take the time and remove yourself from the situation you're in, copy and paste it into a Word document and explain it to yourself as if you were I even sometimes write, explain this as so that a child could understand it. And you get some really interesting response, and you get some, you know, I still didn't do it, and you can actually start to go, explain it to me in a story, you know, and you'll get something out of it. Like, AI is shit and I hate it. It lies to you all the time, but if you use it as a tool and, you know, you don't take anything that it says as the truth, it really will aid you in this sort of shite. One sec. Yeah, Jackie. When a law of the state is inconsistent with a law of the Commonwealth, the latter shall prevail, and the former, to the extent of its inconsistency, be invalid. That is the spiciest sentence I've ever read in legislation. I fucking love it. And this is the thing. We've got this. This is not ammunition in the clip. It's a bazooka, and it's only been used very rarely. And it's sad. It really is. I think it got... Look, the most famous case that it's been used in... Jackie's on fire. She could probably tell me. But in HCA 11 2015, you know, someone Oars v Queensland Rail, HCA 2015 11, they used Section 52XX to prove they're a corp, and then their laws as a corporation... Oh, shit, I might be wrong. Don't quote me on this. Disregard everything I just said, because I actually think either I proved myself wrong or I proved myself right with that, but check me before anyone ever goes and quotes me. Now, look, I could keep going through this, but I'll send this to you in the doc. Let me know if anyone wants me to keep reading. Or I can go on to my statement of claim. Because... like, obviously, I'm getting excited, but could just be saying the same thing 4 times and not really listening to what I'm saying. Yeah, nah, thumbs up, thumbs down, keep going, I'll go into the statement of claim. Let me know.
Yeah, keep going, man.
Get going, bro.
Right. So... yeah, fucking Jackie, I fucking love it. So if everyone's looking at the chat, you might not see it. You might have notifications off. I've only got them on this computer. But yes, HCA 11 Queensland Rail case uses Section 109. I'll quickly explain this. I used to think because they had ABNs, they were a corporation. And this is the case law that motherfuckers need to use. You know, if you're getting foreclosed on because of council or something, I would cross-claim, counterclaim straight into the Supreme Court, use only this, and use the fact that they're for profit, providing services to the private and the public. That's the discernment that's made in HCA 11. So just because you're a public entity, it will immediately classify you as a government entity, blah, blah, whatever. But it is a discretion of the court to ascertain how much of your percentage of revenue is derived from the public and what's derived from the private. Now, that is the discretion that the courts used to go, you are a financial or a trading corporation in this regard. Now, people apply that to the police, and I reckon it would nearly be easier to argue it with the police simply because of what they're fucking doing to the music industry. You can get rappers or fucking your like New Year's festivals, like any fucking event that they hold in a public, they charge the public, whoever's hosting the event, they say to host this event here, you must employ 5 police to come and supervise the event and make sure that there's no fights. By that definition alone, you're putting them up into a high percentage bracket of private business or whatever. And then you go and argue this point and you use those two things, crunch some numbers, get an average. It would be very easy to see how many events are policed each year. You could fucking call them. You could call them a corporation. You could get the High Court to determine that they're a financial or a trading corporation or get a settlement. But if you're going to do this, you'd see it the whole way through, right? But it can be done, but people don't do it. People aren't willing to do this work. Like what I've written up here, you could get a 6-page document why the police are a financial or trading corporation. But people aren't pissed enough. We're all pissed over. I'm pissed about banking, right? And I'm determined to do something about it. But I know, other people, 51XX, was it, Jackie, or 52XX? I can't remember. But I know people, if everyone just picked one thing that, they're pissed about, and then everyone in my group just sat here and went, fuck, T's got this issue, Mitch is doing securities, this other member is, tackling the council, and then, whatever else you've got going on. You pick 5 topics and we all just send each other's documents to each other. We'd do some damage, I can guarantee you. But it's the fact that we've all got so much shit going on. Makes it very hard to keep a clear head, stay focused on the one subject and, hammer it home. But I'd love to take on the cops. That's what this audit's going to do. It's going to open up a door for us. I can't remember where we were. Cole v. Litfield, we went through here. High courts, these quotations demonstrate that while states can make their own laws, they must do so within the framework of the Constitution and in a manner consistent with the common law principles. My interpretation. You asking this question about this and this into AI will tell you if I'm correct in saying that. So, fucking Joshy boy, I'm calling you in, mate. Get on ChatGPT. If you're not, whatever, it's all good. But I know. But if someone wants to do that, ask that question into ChatGPT and then copy the response back into the chat. I'd be interested to see if it applies, and then ask what specific word is this Constitution and common law principle being referenced in these 2 quotes, and then if not, explain to me why not, and then explain what they are, if not that. But this is just a fucking good way to look at shit, and either confirm or ask it the question whether you're wrong or right. Is it applicable in the reality of the judicial system and the framework of the law? And it is pretty honest with you. It might call you a sovereign citizen at one point, but yeah, it's good practice. So the High Court emphasised that state laws should not discriminate against interstate travel in a protectionist manner which aligns with the constitutional protections, common law, blah, 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 free trade. The judgment also highlights the court's willingness to reconsider past interpretations and align them more closely with the Constitution's text and historical concept, which is the key aspect of common law development. Like, I can explain that if anyone wants to ask, like, but I think you guys get it. So Dietrich versus the Queen, the High Court recognized the right to a fair trial and the necessity of legal representation. I did a bit of reading on this, but it was pretty interesting, but maybe not so much. The case underscores the importance of fair legal processes and protections against arbitrary detention, highlighting the necessity for legal standards in law enforcement actions. Now, this one. In Roach v. the Electoral Commissioner, so AEC, maybe, before it became the AEC. I don't think I voted then. The High Court ruled that the Constitution protects the right to vote, limiting the power of Parliament to disenfranchise citizens without reasonable justification. I think this guy was in jail, and they said you can't vote anymore. The case illustrates the protection of individuals' rights against legislative overreach, emphasising that any law infringing on rights must be justified and proportionate. That's right. This case was about they stopped prisoners voting or something, maybe. Or maybe that was in America. I can't remember. Maybe that was an American case law that I'm thinking about, but it said the exact same thing, and I found this one. But here it's emphasising that any law infringing on rights. So there's a High Court case law that they say a law may infringe on rights, right? So something in the past has allowed this judge to say that, right? Because they haven't been able, the defence or the plaintiff hasn't been able to justify that it was disproportionate or I don't know how to say that word. Improportionate. Fuck. Anyway, for him to say that a right has been transferred into a legislative power and someone's argued it and they haven't been able to show the court why. Now, this is the situation we'll get into if we don't have our shit on lock. Okay? Because if you can justify that the detention was improportionate, someone correct me because I know I'm saying it wrong. But if it's not justified, I'm yapping. Anyway. Elaine, what's the opposite of proportionate though?
Disproportionate.
Thank you so much. I felt so dumb. Cheers, Jackie, as well, for chucking in all that shit in the chat. Appreciate it. So, this one, Lang v. Australian Broadcasting, the High Court confirmed the implied freedom of political communication as a necessary element. Look, someone take Instagram to the Supreme Court in Australia to quit censoring my posts. This case highlights the importance of free communication and transparency in holding government and its agencies, including the police, accountable. You'd use the Monopolies Act and, classify these entities. I guess there's no Australian social media services, so it's not really going to work. Anyway, Kirk v. Industrial Relations Commissions of New South Wales, where the High Court held state laws must comply with supervisory jurisdiction of the Supreme Courts. We'd go checking this again because I don't feel like that's right. Ensuring that state laws do not undermine constitutional principles. There's the key point there. This case reinforces judicial oversight over state laws, ensuring they align with common law principles and constitutional protections. Now, here we have our human rights aspect. 3, 9, and 12 arbitrary detention, uphold right to security and safeguard privacy. In that order, I would say. I was trying to think of another word. Then 9 and 17, arbitrary detention or unlawful interference with privacy. Nuremberg Code, not so applicable. But fuck, if someone's pissed off about the inoculations, you know, got to use this shit. So look, by conducting police audits and challenging unlawful detentions and arrests, we can, as a collective, ensure that law enforcement operates within the bounds of the law, respecting common law and constitutional protections. These actions help prevent abuses of power, uphold individual freedoms, and align with domestic laws and international human rights standards. In doing so, we contribute to a just and equitable society where the rule of law prevails, and individual rights are protected. Now, here, the High Court has consistently upheld common law principles and constitutional protections, ensuring that state laws do not contravene these fundamental rights. By doing these police audits, we will maintain this balance and prevent overreach by the cops. Judicial oversight, High Court rulings such as Kirk and particularly Hamilton emphasise the necessity of judicial oversight to ensure that states' laws comply with the common law and the Constitution. Police audits will highlight instances where law enforcement actions do not meet these standards, and it prompts the necessary legal scrutiny and the reform. This is what I'm after. And this is what you were talking about. Is there a board that we can go to? No, the Oversight Committee is the Supreme Court. That's where, unfortunately, we're a police state, you know. We're a country. Australia's run by convicts, still, criminals. Historical and international. Look, this I liked. The requirement to produce identification documents upon request can evoke memories of authoritarian regimes. International human rights instruments such as these three protect against such abuses. Police audits help ensure domestic laws align with international standards, safeguarding human rights and freedoms. Comments before I go into my statement of claim. What have you got for me? Nothing. It's fire. I know. Cheers. Nah, look, but seriously, this part here is, you know, are you going to get into a court to say this? I don't know, but I'd like to. Let me see if I can drop my statement of claim in there real quick. Question, Sar. Surely someone's got a question. What gives you the right, Mitch, to do this?
I've got a question, bro. It's a little bit unrelated, but so what happens after a traffic stop and you don't get in first with a claim, and the cops end up putting charges on you, say for obstructed police or failed to identify? Does any future claim that you have depend on the outcome of their charges?
Excellent question. I'm just searching this. So this is where doing what's known as a cross-claim, counterclaim. If one does this simply in the magistrate's court, I don't know. But this is where we remove that unknowing. We file a cross-claim, counterclaim in the Supreme Court, I can't remember what it's called, but the higher jurisdiction of the higher court, your filing in a jurisdiction higher than that which they filed against you overrides their ability to adjudicate the matter before yours. Does that explain it?
Yeah, definitely explained it. It's interesting because, like ever since the copper smashed into my window, I haven't, gone ahead with anything, but I've had the charges come against me now, and I haven't made a plea yet. But yeah, it's just interesting hearing you talk and then trying to, think about what my options are. Obviously, when it first happened, it would have been better to get in with it then, but it is what it is. So it's just, like I say, it's good to hear you talk on this topic.
Yeah. Were you about to say something, Jackie? Because I'll answer that, but I'll probably rant.
Yeah, it just depends on what sort of time frame you're looking at for your magistrates court. But my thinking would be you could run these concurrently and refer to your magistrate's case number in your Supreme Court documents.
Yeah, okay. Well, they can't hear them. If you've put a filing in, it immediately puts a stay. So if they've got, for example, if you're getting bailed up, I wouldn't do the day before, and again, don't take me on it, but if you've got a week before your, pre-trial or whatever it is, you can go file in the Supreme Court and cite this case number and then write up your statement of claim and affidavit, throw it in, submit it in the Supreme Court, and you'll get someone contact you, something will happen, or you might have to notify. You would send the magistrate's court to which they've got a hearing in a notice saying, I've got this filing, this case. You'll immediately get a case number reference from the Supreme Court. You'd send that documentation to the magistrate's court, and that will put the stay. So you won't get them heard concurrently. If you go to pre-trial, and I think if you file Supreme Court filings mid-trial, you've lost that ability.
Yep.
You would be doing an appeal then into the Supreme Court after that matter's heard. But again, haven't done much stuff.
Yeah, that's great.
So yeah,
But again, so that's sort of, would it be fair to say if you were going to make them filings, you couldn't come into that half cock. You need to know exactly what you were going for and how to go about that. Is that fair to say? Is that your point? Is that one of your points, or not necessarily?
Yes, you could do that, but I didn't follow my own advice, Jamie.
Yeah,
I filed before I knew what the fuck I was doing. Like I sued the bank before I knew what I was doing, and it forced me. The fear of not knowing what I was going to say forced me to, you guys probably see I'm up at like 5:30 some mornings doing shit. Like I was, I get up before work and fucking do a bit of cramming, and I don't work till fucking 7 o'clock at night anymore. I work short days, and I plan my life around this sort of shit. Yeah. Because I realized that I'd done something very serious and I needed to back up, not just be all bark. I needed to get some bite in what I was saying, and I actually restructured my life around it. So in saying that, your Supreme Court, I don't know how busy it is. You might get in pretty fucking quick, but, I'm 6 months down and I haven't even had pre-trial, because adjournments and settlement offers and shit like that have just been pushing it back.
Yep.
Do you know what I mean? So.
Yep. Yeah, absolutely. How that? Yeah, it feels the same. Where it's sort of like, you've gone into it and then realised you need to know a bit more about it, and there's not enough fucking time in the day, and it's fucking intense. It's intense, but it's killer to hear you speak on all these things, man. Again.
Yeah, people don't talk about court as seriously as it needs to be, and like doing all these sort of letters and shit like that. People think they can sort it with a letter, and I'm of the position now that you like everything you do, you need to be ready to take to court. But it doesn't go like that. But if you've got that mentality, you take it a lot more seriously. You know, if I was in your case, I would wait it out as long as I could and do some research. I wouldn't wait it out as long as I could. I would kick back for a little bit and figure out what it is, the one point that you've got that was wrong with what happened, and then you'd write a statement of claim around that one point whilst referencing like the human rights thing. Maybe you'd go for the damage. I forgot you were the bloke with the where they banged your window in. You could go at them for the damages, the human rights, you know, they fucked with you, they hurt you or whatever. You would list the series of events that led up to you've breached international human rights laws, federal legislation and constitutional protections against arbitrary detention. And then you've essentially wrote up a statement of claim because you list the events. Like, as I'll open it up so you can see it on the screen as I'm talking about it. All right. Am I? No. You're going to be seeing the old screen now. Hold up. So, what? Man. Oh, wait. Yep. All right. One sec. Here we go. So, new screen, yeah?
Yep.
All right. Statement of claim. It's not laid out like this because if you ever file a claim, you need to go pull it off the court that you're filing in, and they'll have a form that you fill out. So it looks a lot different to this. But blah, 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 introduction, who they are, jurisdiction. So change this to Supreme Court. Now, factual background. On this date, the plaintiff was approached, pulled over, whatever. The following exchange took place. I asked, what right? Give me your shit. Can you please tell me? This is how I will lead the conversation to the claim that I'm making, right? Like, this is how I've always tried to do it when I was talking to police. I would control the conversation, and it's not easy, but you would essentially be listing the following exchange. You'd lay it out differently, mate, for sure, but you would be listing all the things that happened and you wouldn't write the conversation like this. It's only because I'm using this, but you would list all the things that happened. They've detained me. They couldn't tell me what for. You know, there's that issue there, right? That's issue one, unlawful detention. Then issue two is, you know, I don't know if they pulled their fucking pistol out on you or whatever, but they intimidated you. Then, you know, there's intimidation issues. Then they've, you know, yelled at you. Then they broke your shit. They damaged your property. They trespassed on your person by, you know, they touched me when they had no lawful right to do so. You know, they assaulted me. You'd run a part of the assault process in there, and you would document the things that happened. And in your statement of claim, you would say, you know, I'm going here, the unlawful, just pretend you're doing it the same as me, the unlawful detention and blah, blah, blah. You would then, you've now listed all the things that went wrong. So then you write that affidavit where you go, the evidence for unlawfully detaining me is here. The evidence for trespass on my person was here when they fucking touched my shit. The evidence for the damage of my property happened here, and then here's where the evidence, you know, you can't break my shit, right?
Yeah.
And you write some stuff about that. And then third is the fourth is the assault. You know, they assaulted me. Okay, so you've got a statement of claim that writes out the series of events. Then you write your affidavit that supports what happened with the evidence. And then you cite, if you go back and watch your videos, they're probably going to cite a road rule somewhere maybe. And then you go back through and you rebut what they've said, what they've gained their lawful authority to do so from. So then you go and file, right? And you'd go and file that. You'd go get copies. You'd get it all stamped at the court. They would take 3 copies. You keep one, they keep the other. Then you take the third and you'll go file it on the Director of Public Prosecutions. I don't know. You might file it on the precinct, the cop himself. I know you won't file it on the cop himself. That will be a later date if you decide to pursue it. But you need to get through the DPP first. You'd go and serve someone on it. That initiates the stay on proceedings, and then that will start the process where you'll get a phone call with the clerk or something. I can't remember his name, but someone within the court will call you and they'll tee up a time. They'll tee up a pre-trial time, and then they'll tee up a hearing time. So probably within a week or 2 weeks of you filing the application, it might be different because it's in Supreme Court. It might happen quicker, but usually the defendant would potentially email you some shit. They file some shit in the court saying they're going to try and dismiss the charges upon, lack of basis for a claim or something. So you might get one back and forth between an entity, and then you're going to have a registrar. The court registrar will call and set up a pre-trial and then a hearing date. Okay, and one's going to be a month from that time, so you're probably going to have 2 weeks and then a month on top of that, and then you might have 2 months in between the pre-trial and the hearing. So what that enables you to do is you submit your statement of claim that covers off everything that happened, and then an affidavit to which you're going to base your argument around as your evidence. Now, what you can do is you can pretty much get as many as you want, but you don't want to fuck around the court, but you can actually make an appeal or a plea to the court and the defendant that you seek to amend your statement of claim. And you would just add new affidavits, but you would seek leave to amend your statement of claim if it's within 21 days. You would seek leave to amend your statement of claim because you didn't construct your argument as concisely as you wanted, or there was one additional point that you missed. So this is crucial because you don't want to fucking lollygag and not do your statement of claim and your filing, because you're going to miss out on crucial time to which you're going to have to sit with what you want to say and do. But it's the biggest learning curve when you submit a document like this and you go back and read it after you submitted it and you're like, why didn't I put this in? Well, there's a way out for you, and that's a plea to amend your statement of claim, which they will grant so long as you're just not making a whole new claim. And if they say that you've made a whole new claim, which I don't think you will, they go, well, fuck it off, and you then just go and resubmit a new one. Okay, so don't rush into it, but also don't fucking not do it. Because I think this is your own, unless you want to just, deal with it, you should be stoked. I used to think it was scary, Supreme Court, High Court, but when you understand the Magistrates Court and how fucked it is, you want to get out of there ASAP Rocky. You don't want to be in there because they're gonna fuck you. They're just another level of cops ensuring their quotas are met.
Whereas that's how it seems, man. Just I'm far from learned on it, but just reading a little bit of case law and some examples, recent examples, it's like they're so belligerent you can't know which way they're going to go. In one state to the next, from one day to the next, they do whatever they like. In magistrate court.
I can tell you where they'll go. They'll go in the opposite direction that you want them to go. Like you can guarantee they're not going to do what they're supposed to do. It's sad, but it's our judicial system, and we've let it get to this point. I can't blame anyone else but myself. When I was a youngster, I used to make trouble for the cops. I used to drive slammed cars and shit like that. And when they pulled me over, it was a game to me. And I always knew it was wrong, and I should have done something about it then. But I decided to get a work van and fucking stop. I had a track car and stopped. I sold that and just started. I'll just sort my life out. And I take it personally that I didn't do this earlier, and I only blame myself, because it's just like, bro, no one's getting held. No one is getting held accountable, and everyone's taking settlements, and I'll fucking take one, but I'll take it the reason why I'm so fucking like a dog with a bone with this shit is because I'm determined to do the legwork so that I can go in there and fucking set a precedent. That's my goal, in any way, shape, or form. But it's our own fucking. Us being punces is what has led us here. The collective. Now, if you fucking sack up and want to, go do it, like the crew here will, we don't do shit for people. Like, we don't do the work for them. But me doing this, me sharing all my bank stuff, me sharing all the credit card stuff. Like, if another one was to start doing this in my group, like, I would actively be helping them. But it's, again, I'm not going to say I'm going to sit there and do it all for you. But, if you decide to take this on, I will do what I can to help you cut it back, edit it back, and fucking, give it the once over. But it's, you got to want it. You got to want it. And, because it's just going to happen again if you're running no shit or you just don't want to, comply. Like, it's only going to get worse. And that's why I'm so adamant on this police audit stuff, because they're going to start demanding shit off you more and more. And it's got to start somewhere. And I think this is a way we can do it. I don't know, brother. You're in a predicament. But then again, bro, it's the exact same thing as your shit's serious to you as this audit is to me. To be honest with you, it's just happened to you before, quicker. And realistically, it's the exact same thing. It's pretty serious because what, they were yelling at you, they broke your shit. Bro, I look at that because it didn't happen to me, but I look at that and I'm like, oh, you've got all the fucking evidence in the world that they're going to want to get rid of your case. You're not going to take it to trial. You're going to present this shit, go in there, liquidate damages up to fucking, I don't know, $250,000, something like that, and say to them, this is what I'm doing, and this is my affidavit's 2 pages long. These are the laws you broke. This is you relying on this law. Here's all the case law that state what you did was unlawful. Do you really want to go toe-to-toe? Do you really want to explain your actions, your police officer's actions in a fucking Supreme Court with a full room and, or do you want to liquidate these damages down to 20%, 25% if you've gone high? If you've gone low, you'd say 50%. If you lock your shit in, they're not going to want to deal with it. I've got 2 documents that I'm not allowed to release of people, how we told you about that human rights shit? This fella how much of this I should share, I don't know. But anyway, this guy's got guns, and he got pulled over for doing some driving shit, and they took all of his shit off him. His car license, his gun license, his guns, all of that shit they took off him, and he had the matter go through magistrates court, lost. He turned around and filed an appeal in the High Court, in the Supreme Court. He didn't even get to pre-trial. The DPP sent him a letter and said, can you please remove this, and we'll give you this one thing, his license back maybe. And he said, I'll do what you asked. I'll conditionally accept your offer if you give me back all my shit that you took, all my licenses and all my properties, return my guns to my house. And they said, yeah, no worries. I've got the letter from him to the DPP and the DPP back to him. Bro, far worse than what's happened to you. He fucking did something illegal, and they pulled him up on it, and then he argued it in court, lost in a magistrate's court, and turned around and appealed it in the Supreme Court. Like, I can't imagine how that bloke was feeling. Like, I don't know who he is, whether he's like as confident as my buddy that sent it to me. Maybe, maybe not. Either way, he had a whole heap of losses. He got jerked, got his shit took. He's an older fella, can't drive, can't work, struggled to drive, struggled to work, and then turned around and dealt with all of that for 6 months, maybe 4 months, a turnaround, maybe less, maybe more, and then goes, you know what, fuck this, these guys wronged me, and I'm going to follow through. I'm not going to take this line down. Files in Supreme Court, spends months studying, and they turn around and say, please remove it, I'll give you this. And he goes, no, you'll give me everything. And they go, okay, here's your shit. Bro, done, like that. Didn't even, 3 weeks later, 3 weeks after he filed it, there was 2 emails back and forth, and then he got his shit. No criminal conviction, no record, instant dismissal of all prior convictions. Just because he believed, he knew he had been wronged, and he was willing to see it through. Now, no false hope, but we're still trying to get his documents off him, and I think he wants it all to get settled and finalised. He still might not even give it to us, bro, but I don't need to see his documents. I know he just stood on his fucking business. And you can too. But it's just you know, saying less but enough and fucking following through. What say you, Johnny John? Say make Supreme Court your friend. Is what I reckon.
Yeah, man, I think I just need to get studying, keep listening, you know, keep reading. Well, get to it. But so I guess that's what I'm trying to figure out, like whether it's there's something I need to do ASAP, you know, before this goes ahead in magistrate court, or whether it's something I can spend a bit more time digesting first. But, you know, I'm sort of just trying to figure out at that point.
Bro, fucking, you know, here's what I wouldn't do.
What?
Let it go to magistrate's court and fucking have a crack in there, and you know, let him rule against you and take your shit, and then go turn around. You've just got more damages. This guy could have liquidated his damages and fucking said, "Give me a payout." You know what I mean? But he just wanted his shit back. I even said to my bud, I said, "Where's his do not detain order that he wants put on his fucking license plates and all of his registered vehicles, so that when they scan his shit, they go, don't pull him over."
Yeah.
We have them in Australia, but people don't fucking follow through with them. Do you know what I mean? So, like, this guy doesn't know it all. Like, I know if I got settlement from the DPP, that'd be the first fucking... I guess he probably wanted his guns, but it'd be the second thing I was asking for. I want a do not detain order so this shit doesn't happen again.
Yeah.
Or I'm going to fucking court and you're going to have to explain your BS to the judge there and convince him that you were right. Not you were right, the DPP that just fucking tried and sentenced you and got a magistrate to rule against you after you go and present pretty much the same evidence that you're going to present in the Supreme Court. And that's a shit show. So, like, you know, I don't know if you've got your license on the line and you need it for work or whatever, but you could essentially go in there and let them shoot themselves in the fucking foot, because that's a thing you're supposed to do. You're supposed to exhaust all options, right? Like, even with your letters, your complaints and all this shit, you're supposed to exhaust all options. They frown upon you just literally skipping all the BS that they put in front of you and filing in the Supreme Court unless you've got a fucking valid claim, which you do, and he did, and this does. But you're within your rights to let the judicial system take its course and then ask for remedy or relief after you've had your rights infringed again. Like, there's a million ways.
So it would be so it's better off to have made a complaint with the police, made a complaint with any human rights foundation, and then additionally make the claim in Supreme Court.
Don't bother complaining to the police, because the police have wiped their hands of it the second they've ticketed you on the side of the road. The coppers are out free and clear, bro. It's not even the copper that booked you. He's got nothing to do with it unless you decide to sue him after the fact. They get that ticket issued, and then it's like, fucking you beauty. We get that tick. We've got that. You've got the receipt, right? They deposit all government entities deposit their receipts into the special fucking entity or special entity and trust monies account. They all deposit their receipts into there. So your booking got a receipt. They deposit it into their trust account. The station gets paid. The precinct gets paid. Everyone gets paid, and they're happy days. And now that they've booked you, and if you decide to fight it, or in your case, you get sent to court, the next round of motherfuckers get paid. Yeah. Right? It's got nothing to do with the cops. You can go and file in the human rights case. That might having that little receipt number on your affidavit to say that you filed with the UN and the AHRC, but it does nothing. They're not gonna back down because you've got a human rights complaint. They're gonna back down because you've pulled them up. You've called their bluff.
Yeah.
Good question, though. But, yeah, like, I wouldn't go through the magistrate's court only because I know, but it's, it's up to you.
Oh, it's great. It's great to hear that, because I didn't know there was an option. I didn't know that process. I didn't know that one excluded the other. I didn't know any of that till just now tonight. So that's really given me some actually food for thought. I can actually have a think about some options. At this point, I was just wondering whether to, what to plead or how to even interact, in the next time. So now I know I can actually make a real decision, and that's get my shit together and get a statement of filing in the Supreme Court, or go through the shit show at magistrates. And it's like could probably be pretty certain it's not going to end well for me there,
Yeah.
Short of going in and fucking studying for the trial and learning about that, like, just to fucking go round and rounds in circles. Even a not guilty so-called win in magistrate courts, a lot of fucking effort for fuck all, eh? You're not walking out of there with any money.
Yeah.
Tell me if I'm wrong, but...
No, if you go into the magistrate's courts, you're playing defense. Any evidence that you provide is you're arguing against theirs, and it's just not going to work. The only way that you can have a fair and equitable hearing is doing a cross-claim, counter-claim. Now, you could do that you could do that in the magistrate's court and keep the damages under 20K or 10K, whatever it is. I think it's 20 in New South Wales, but you're going into a magistrate court. There's no judge; it's a magistrate. So it's just your only option. Your only option is going Supreme Court with a cross claim, counter claim. If you want to be able to talk, you're going to be responded and scolded in their hearing. Whereas if you do some counteraction, because right now you've got the hot potato, my friend.
Yeah.
You've got the metaphorical potato, and you're holding it like a sucker. No. But this is like the tennis analogy. It's like you're playing a game of tennis with them, and by you appearing in their court, they've just done like a fucking foul ball served. They've served you a foul ball, and like we fucking dive at it and like and fucking hit it back like dumbasses. We could let it bounce out. Then what do? We let it bounce out. That's our serve. Where are we going to serve with a cross-claim counterclaim in the Supreme Court with our own evidence, so that they've got a fucking, fucking Johnny over here might have a 200-kilometer fucking power serve, and they can't hit it back.
Yeah, right.
You pass the hot potato to them, and they hold it like chumps too. They can't cross-claim counterclaim you.
So what's the cross-claim counterclaim? That is in response to their charges. Is that what that sort of means?
Well, they brought a claim against you, and you're doing a claim back. That's pretty much all it is. Like you can't do a cross claim. You can't do a counter claim if they haven't filed against you.
Okay, right.
You're just doing a claim then. So the cross.
So
it's just a description.
So is that your standard terminology? Is that what I'd be looking for? The filing it in WA, would it? You'd be fair to say?
I believe the legal term for it is a cross-claim counterclaim, but there'll be a file. Don't quote me on it, but bro, you could have ChatGPT up while we're talking. You could have half your statement of claim done by the end of this live. But you can just type that in. I've literally start a thread and go, this has happened to me. They've filed this on me. Now I want to do a counterclaim against them. Tell me what the form is that I'm supposed to use in the Supreme Court in WA so that I can fucking file this. And, and it'll tell you, it'll put a link there, bro, that you can click probably sometimes. And it takes you straight there.
Yeah, no, bro, fucking oath. I'll check into that. Yeah.
Bro, hit me up. Hit us up next Tuesday if you want, and fucking, I'm sure everyone that's in this chat would be, we're all like, I didn't know this shit until I started, and like, I had a group that I just asked questions to, and they would just send me a 600-page book and go, read that, and I'd be like, fuck. But they all helped me out once I showed that I was actually they'd do another live the next week, and I'd be like, right, what about this, this, and this, and this? And they'd be like, okay, you've read that book, have another one. Right? But, like, I've gotten to the point where I can kind of articulate and then at least know how to search what I don't know, and I'd be willing to, if you want to do a call again in a week's time, same time, and we can actually answer your question.
All right. Well, I'll get to that, and in the next week, I'll have some questions and stuff for next week, bro. Thanks.
You're right, brother.
Well, just something to present as well. So see how you reckon I'm going with it. All right, bro. Yeah, that'd be wicked.
Yeah, and then I've got this document here. You might want to just go pull up that the Supreme Court counterclaim form, and it probably is going to look very similar, but just blocked. It's got boxes where you enter your details and that, and just plug in a few bits of information, and then we can I'll let you share screen and I'll do it too, and we'll fucking we'll just sit there and fucking bang out some shit for you, and it'll actually expedite the process for you a lot.
Awesome.
I fucking hate cops, so I'm down. If you're going to take it all the way, I'll work with you. I've got mates with cops. I do all the electrical and the TV work for like one of the motorbike highway patrols, and like he actually knew about me because I had my local highway patrol used to have it out for me. He would like I used to have heaps of cars at my house, and we'd park some on the nature strip when we'd have like drinks at mine, and he would pull up at 6 o'clock in the morning and like throw his sirens on and come bang on my door and make me move my cars and shit like that. And the coppers like knew about me because I got away from him 3 times, and he like, back then there was no Skies law and shit, and like he didn't get my plates, he just knew the colour of the car, and there was only like 3 other cars in the Hills district that were that colour, and he would like, he talked about this fucking guy, they got away, and this copper knew about me, and I'd say to him, you guys are you're all dogs. Like, I used to get defected. My car I had a different engine in it. It was engineered, and it was below the capacity that you needed to do. And he'd just defect me on everything, and he'd be like, yeah, that cop, everyone hates him. They know him all through New South Wales. He's been shuffled from so many precincts because of, like, you know, overreach. He just causes so much drama. But, like, there are good cops. I'm mates with him. You know, I've had beers with him and stuff like that. There are good cops, but fuck, what they're doing now, man.
For the most part, they just seem to be trending downhill. I don't know, like, at least in my experience, and it's just, you know, you look around online or whatever, and it's just like more and more of the same shit. And you see mass exodus now of them. It's like, you know, it's so good to have some type of remedy at least to strive toward, you know, to try and limit this fucking carry on.
Something we got to be mindful of too. Everyone in this group here is we see videos of police being painted in that light. You know, they've got a couple $100 million marketing campaign where they're making videos that promote police in a good light, and they're displaying them to the public like that. So the other side of Australia, I think it's 33%. So the other side is the 66% that are being shown police in a good light, and they make anyone who asks questions of the police look like fuckwits. So there's a discernment that must be made there that we're being shown what we want to see, and the other party is getting shown the polar opposite of it. So,
well, if you're not interacting with them, you'll only ever see what the media tells you.
Facts. All right, enough of that. The statement of claim, I'll run you guys through it real quick, and I guess my logic behind the interaction that I've written out here. I guess, yeah, look, what we'd be doing here is Supreme Court, pursuant to Supreme Court, blah, blah, blah. Now, factual background. On this date, at this time, this happened, where the plaintiff was approached by the defendant. Now, I'm not sure, you guys probably would have seen that the other script that I had, where I think Josh was asking, like, what are you getting at? And so I just sat there and wrote, like, I used to write multiple a week of that, just to, when I was first, you know, cruising about in my automobile, doing my thing. I was, you know, I can speak this conversation off the top of my head. And it was a little bit longer, but for brevity, the police comes up to your door. Produce identification. And then there would be 2 or 3 that are before this, where you're trying to be diplomatic. But this is the issue, right? I need to see your identification. Now, what's your reasonable articulable suspicion? So your RAS, you could be a bit of a funny bugger and say, officer, what's your RAS? Or your probable cause. There's another like 3-letter word that's used to describe the other one. I'll edit this and probably chuck that in. So what's your reasonable articulable suspicion that I've committed or am about to commit a crime? The High Court has established that for lawful detention to occur, it must adhere to common law principles, constitutional protection, and be in line with High Court case law. Any deprivation of liberty must be clearly justified by law. So you would split that, he would respond, and you would state, did you know this? He would then double down. You're being detained for identification purposes. Officer, lawful detention requires reasonable and articulable suspicion of criminal activity based on the facts. It is grounded in common law principles, High Court case law, and constitutional protections. Are you relying on statutory powers? If so, remember that these still must comply with constitutional limits. If you don't provide ID, you will be arrested. Bang, this is your claim right here. $signs we put here because that's our liquidated damages. The officer has broken the law by saying that. He has made the claim that not providing identification details is a crime. Okay? So this is where we use statutory powers, right? Statutes are okay, but he stepped outside of statutory powers. So you kind of want him to quote. This could be edited to be a lot better. All right. I probably could read the one that I posted in the chat, but you want him to step outside of his oath of office, right? Which would be the grounds that he relied upon up here, further up in the conversation. He would have said, as per the Road Vehicle Safety Act, the Road Transport Act. There's like 3 or 4 of them. He might even quote LEPRA, which is another police powers document. Based on this, you must. It's on my other computer. I might show you guys if I can be fucked. But you want him to state something that he's doing this because of this, and then what you turn around, you might have to say 2 or 3 different things because he's been trained to say one must provide identification details or you may be arrested. No claim there. If he locks you up there, your statement of claim needs to be written differently. You need him to state these words or by his actions support that. Now, I'm going of the position that you've got to entrap him into this specific sentence. This is where the claim lies that you can make. Your cross-claim, counterclaim goes against his claim here. Okay? And fucking Johnny boy, you might even be able to watch that video and you might be able to clip something out of it where that might be good for you, bro, if you can clip something out of it where you think the copper might have actually incriminated himself by saying something to you. Now, officer, you need to articulate specific, reasonable grounds for detention beyond simply citing a statute or an act. The High Court has ruled that statutory provisions can be invalid if they violate constitutional principles, even if they are authorized by legislation. The Constitution is the supreme law and all other laws must be consistent with it. I wouldn't put that. I would put the High Court rulings are the common law and all like statutory legislation must not, extend beyond it. I think I'm getting tired, but I think you all probably grasp what I'm trying to get at here. I wouldn't like to say with a copper on the side of the road, the Constitution is supreme law, because you've been labelled then the moment you say something like that. So you would say the High Court case law has ruled that for lawful detention, it must be in line with, the principles and protections as set out by something else. And all the laws must be consistent with it. Now here, moreover, the principle of legality presumes the Parliament doesn't intend to interfere with fundamental rights unless clearly stated. The separation of powers doctrine limits the government's power to detain without judicial oversight. So I request you call your supervisor to the scene to explain the legal basis for this detention. So they're supposed to, but if you've pissed him off, you're in cuffs and in the back of the divvy van. So if you've maintained composure throughout this, you will be able to request a supervisor. He might actually go, oh, fuck this. He might, if you make him think about what he's said and done, he might go, you know what, I fucking don't want to deal with this actually. This is getting a little bit too much. He might just dip right there and then. He might call his supervisor and his supervisor might give him a spanking and let you on your way. Or you might have got a rise out of him and he wants to prove a point. If he was a fuckwit back in school, he sees you as the bully or whatever, and he'll want to, exert authority over you, and you will get arrested and taken back to the fishbowl. Now, here's your point. Despite the plaintiff's articulation of legal principles, the defendant continued to detain the plaintiff for time, 15 minutes or 6 hours back at the police station. And I think there's a precedent where you can charge $5,200 a minute, or I can't remember. Someone said there was some wild number for a second, but I don't think it's legit. I couldn't find it. But then without providing a lawful reason or demonstrating reasonable suspicion of any, I don't know if that's the right word, offence or of any crime being committed, maybe, might be better. Now, the plaintiff was ultimately, so this is the detention, the plaintiff was ultimately released without charges, having been subjected to an unlawful detention. This is fucking very fucking simple, right? And you're arguing this the whole way through your affidavit. You're providing evidence to support why that is not the case. Your human rights, your 3 human rights conventions with 2 articles in the Universal Declaration, 3 in the ICCR and 2 in the ICESCR are going to support that this is not okay. Then your common law principles are, you're going to probably nail home Hamilton and maybe 2 other case laws that support arbitrary detention, unlawful detention. Then you're going to use 4 or 5 case laws that support 4 or 5 case laws that support, like, the Constitution must, the legislation must not extend beyond the constitutional protections offered for us. You're going to cite maybe 10 points of specific evidence like that, and then you're going to expound on them a little bit, right? Now, legal basis for the claim. The defendant's actions constitute unlawful detention in violation of High Court case law, common law principles, and constitutional protections. Don't know why I've written that. The defendant lacked reasonable, articulable suspicion or probable cause that's the other one there, probable cause, to detain the plaintiff contrary to the requirements under, you've got the Powers and Responsibility Act, and then you're going to put Road Safety Act, Section 59 of the Road Safety Act, Article 11 of LEPRA. I can't be bothered checking my other computer. So you're going to put a few legislation in there, right? So that's their acts that they're relying upon, and the defendant, point 11. Oh, wait, here we go. The defendant was arbitrary and disproportionate. What? Oh, the detention was arbitrary and proportionate, violating the plaintiff's rights under Article 9. So that's the ICR, ICCPR, and then UDHR, your ICE, SCR is going to be your human rights violations there. Now, allegations here, the defendant unlawfully detained the plaintiff without reasonable grounds. I would say without lawful grounds or reasonable. He wasn't able to articulate the reasonable suspicion of a crime being committed or about to be committed. The defendant's actions were not necessary or proportionate to the circumstances. Brother John, this is, should be ringing bells to you here. The defendant failed to inform the plaintiff of the reason for the detention in breach of legal requirements. The harm suffered. Again, you're going to expound on this. As a result, blah, blah, blah. I had my property fucking touched. There was trespass, not only upon me, but my property. They broke something of mine. I was manhandled. What is that? Allegation. I was assaulted because they picked me up, took me out of my car and cuffed me. I was assaulted here. I've suffered mental damage. I now can't operate as a functioning member of society because of the unlawful actions. Now, relief sought, you want to try and keep it simple. You're going to liquidated damages will be here, and then you would reference how you got there in your affidavit. So you'd be citing some Crimes Act shit, and then the penalty units, and then the liquidation amount, and then you'd be using your time, because you will have recorded all of this. So you will have a time start and a time stop, and then you'll know what time, if worst case scenario, you get taken back to the fishbowl, you should know they'll have a report and they'll know what time they released you. And then you sting them for a fucking huge Uber fee for the way home and food and shit like that. So damage, relief, a declaration that the actions were unlawful, and a fucking formal apology. Damages, liquidated damages, mental implications and cost of, loss of employment, business, issues, costs of this proceeding, any other relief the court deems proportionate. They're not going to deem anything proportionate, so you've got to demand it. And there we go, award for damages for time spent unlawfully detained. And then the plaintiff requests that the court grant the relief sought. Now, here's that. And then here's what a little what I've wrote. I gassed out by the end here, but your affidavit. I think you guys, I've explained that pretty clearly. We need to go through and understand the constitutional protections. We've got the common law principles. We know what that is from my Instagram little write-up that I had. But yeah, any questions on that, lads and lasses? Fucking mouthful of glass there. Say again, Jack.
You need us to go out and find some constitutional protections.
Yeah. So I think where I need to invest some time is finding the constitutional protections. So one is the constitutional protections. Two is where the police are gaining their authority from, and I'm pretty sure we might have covered that. The LEPRA, Police Powers, Road Transport Act, and I think the Road Vehicle Act. So what we need to do is constitutional arguments in High Court, and then the constitutional protections, and then pretty much like the affidavit is the crux of the matter here. But yeah, I think, were you thinking about how you could help here?
Yeah, I just want to know what holes we need to fix.
well, I've got like a bit of brain fog at the moment, but my head's lying on how to structure the argument. So I think that's where this is where I'm hung up on. I think what would benefit me from being able to go from stuck on the statement of claim to putting together this affidavit would be, yes, the constitutional standpoint where we could rely on. That'd be probably... I always hated the idea of using the Constitution because I know we're getting stepped on so hard with it, but I think this is where we can use it to our advantage. So, yeah, constitutional protections and the discrepancy between the police powers, the acts that the police are using, that's the two for me. What they're using against us and what the Constitution provides for us. I think that's the two. Like, because I've got the case laws. I just need to do more stuff. I'm back.
Right. I'll have a look at some stuff tomorrow, and I'll just DM it to you because it'll be my own docs.
That'd be awesome if you could.
Yeah. And it may or may not fill in some gaps, and then we can work from there.
No, that'd be lovely. That'd be awesome if you could send me anything that you've got. And I think maybe we can do this again next Tuesday night. And if anyone has any other tidbits that they want, you can just DM it to me or drop it in the police chat, and I will start constructing an affidavit, and we can maybe, I can maybe share screen and do it with you guys or add some shit in it. And then once we sort of get that done and have a bit of a yarn about it, we can potentially come in and like watch me and John nut out his case. And, everyone can just sort of, correct me when I get a bit excited or add in anything that you guys might see I'm missing, which is quite a lot. But I think that's a game plan on how we can actually start making a move. Yeah, productive. I've been wanting to get that out. So appreciate everyone for tapping in. Is there anything else anyone would like to add or ask before we close off?
All good from this end. It's getting late.
I know, I didn't even realise the time. But yeah. All right, cool. Thanks, guys. Thanks for jumping in. Appreciate it. And let's try for next Tuesday.
Awesome. Thank you.
Thanks, Jackie. Thanks for helping.